All right, welcome everybody. Thank you so much for joining us today. My name is Sean McKay, and this is an American IRA presentation. It's a unique presentation today. We're going to get into something a little bit more technical than we typically do for our content. Today, we're going to be discussing the Secure Act 2.0. This is something that went into law at the end of 2022. And so certainly the visuals behind this, and again, the content, what I'm going to be speaking on is a little bit different. So a big thanks to our legal department at American IRA for actually constructing the content around this. So I do apologize again if you've joined us for previous webinars. Usually I have slides that are a little bit a little bit more minimal in terms of the verbiage and the writing on them, and we're just discussing basic contents around investment strategies, the self-directed accounts that we administer, things of that nature. But certainly with the tax and legal implications of the content here today, I'm largely going to be reading from the slides. The good news is that this is recorded, so you will have access to the slides here so that you can go back and listen to it and perhaps go to your tax and legal professionals to get their input on this. But again, today's content, a big thank you to our legal team at American IRA for working so hard in constructing this. So as I mentioned earlier, on December 29th, 2022, Secure Act 2.0 was signed into law. And so there are a number of changes. The great news is that all of the feedback we're receiving, again, from legal and from the guidance that we're receiving, is largely the changes that are being made are actually really positive for us as investors, as savers, whether we're entrepreneurs or we're W-2 employed at some sort of firm. And so we're going to touch on a number of different topics today. But again, a lot of these things are going to be pretty positive for us as we're moving forward in our investing and our retirement savings. So we're going to be talking about the increased amount of allowable retirement savings, the new rules around employees and how you can save for retirement, as well as access to retirement savings for different scenarios that might arise in your life. And of course, the increase in the age for the RMD, the required minimum distribution. For those of you that are at that point in your journey, this is certainly good news as well. And so, as we dig into the contribution concept associated with this new Secure Act, as far as the 401k concept goes, with the maximum voluntary contributions, you can defer for a 401k 2,500 for 2022 or 22,500 for the year 2023. And so, as far as the catch up provisions go, for individuals 50 years old plus, you can contribute an additional 6,500 in catch up contributions in 2022, with a catch up contribution increasing to 7,500 in the year 2023. So, that brings the maximum allowable contribution to 27,000 for 2022 or 30,000 in 2023. Now, starting in 2025, individuals aged 60 through 63 years old can contribute up to an additional $10,000 in catch-up provisions. After 2025, those amounts will be indexed for inflation. So presumably, they will be going up after the year 2025. It is important to note that catch-up contributions for individuals earning more than 145,000 in the prior calendar year must make Roth contributions, so those post-tax contributions to that 401k. Now, the total contribution limits in 2022 for a solo 401k are 61,000 or 67,500 if you're 50 years old plus in age. Those limits actually increased in 2023 to 66,000 or 73,500. So for additional limitations, there are some. If you're a highly paid employee, an employer can elect to stop a participant's salary deferral once that person earns 305,000 in 2022 or 330,000 in the year 2023. Highly compensated employees, also HSEs, also known as HSEs, I should say, or key employees, are employees who meet at least one of the following criteria. They own at least 5% of the company, or they earn more than 135,000 in 2022, or 150,000 in 2023, or if the company elects, they can rank in the top 20% of employees for compensation. So this is another way of articulating what we've just gone through. So again, really when we think about the solo 401k in particular, which of course is the 401k product that we're able to self-direct. So that is an account, a solo 401k that we can administer for you at American IRA. There's really, when you think about it, two buckets. There's an employee, a salary deferral bucket, and then there's also a profit sharing, or essentially an employer contribution. So as you can see again from the slide here, this will be available for those of you that are joining late. We do have this recorded, so you'll be able to reference this and go through this in your own time. So there are some incentives to save more. And so with the Secure Act 2.0, it's providing a few different concepts. One of the ones that I'm actually most excited about is the Simple and the SEP plans, which are small business plans. These are accounts which historically have been purely pre-taxed dollars, so similar to a traditional IRA. There are some interesting new features there. Also converting a 529 plan, which is a pretty typical college savings plan that you see. Usually it's designated for a particular state. There are some interesting new concepts there as well. And so we'll dig into a lot of stuff here. So as far as the Simple and the SEP IRAs, these are accounts, again, historically, which have always been purely pre-taxed monies. So the benefit has always been there's a deduction for contributions made to those accounts. With this new law, you're able to make post-tax contributions to both Simple and SEP IRAs. So of course, the benefit with post-tax or Roth contributions is that you're able to grow those funds in a tax-free manner. And so ultimately, if the account is open for 5 years, and you're 59 and a half when you start to take distributions, you'll be able to withdraw or take money from these retirement accounts tax-free, which is certainly a pretty amazing feature there. So something to keep an eye on there for those of you with small business plans that may not be eligible for a solo 401k, because of course the solo 401k product is meant for those that are self-employed and do not have full-time employees. So for those of you with small businesses that do have full-time employees, simple IRAs and SEP plans can be a really great feature. Now, as I mentioned, there's also the ability to convert a 529 or a college savings plan to a Roth IRA, which was previously not available to us. So starting in 2024, with certain restrictions, funds in a 529 plan can be transferred into a Roth IRA for the beneficiary of the account. So if we put this account together for our child, the child will actually be able to move this money into a Roth IRA for that child. So in order to qualify for the transfer, the following things must be in place. So the 529 must have been in effect for 15 years or more prior to the transfer. The amount transferred is limited to the total contributions made to the plan within the preceding 5 years, and the annual amount transferred is limited to the amount allowed as a Roth contribution. So it is important to note that the total amount that can be transferred is capped at $35,000. So there could be a remaining balance of $50,000 in this 529. Let's say that your child was able to obtain some scholarships, or maybe decided only to go for a limited amount of time to college, or whatever the case may be. The amount is capped at $35,000 being moved to a Roth account. So as far as the solo 401k retroactive deferrals, a new solo 401k plan adopted after the end of the taxable year, but before the employer's tax filing date, may receive employee contributions up to the date of the employee's tax return filing date for the initial year. However, elective deferrals must be made by the tax filing due date with no extensions. So employer contributions may be made up until the tax filing extension deadline. So, in terms of options for employers, there's a matching for Roth accounts. So, employers will be able to offer their employees the option of receiving matching contributions to the Roth account. There's a student loan repayment concept. So, starting in 2024, an employer can offer a matching contribution equal to the employee's student loan payment to give employees an additional incentive to save while paying off their student loans. Beginning in 2023, employers may offer small financial incentives to help boost employee participation in a workplace retirement plan. So that could be gift cards, things of that such. So as far as the automatic enrollment in retirement plans, so again, this is for those of you that have the W-2 type of job. Beginning in 2025, employers with more than 10 employees offering a new 401k or 403b plan must provide automatic enrollment for new employees and automatic escalation of the amount of an employee's deferral. So this requires an employer's plan to have first, a starting salary reduction for new employees of 3% with a salary rate reduction of 1% annually until reaching 10%, but no more than 15%. These plans can include automatic portability to a new plan if an employee changes jobs. This change would encourage employees with lower balance accounts to continue saving instead of cashing out when they change the job. And employees can opt out of the plan if they do not want to participate. So, highly encouraged, but again, you do have the capacity to opt out if for whatever reason you're not interested in this. Now, obviously, this isn't core to our role at American IRA in terms of being a self-directed IRA provider, but the legal team again did a phenomenal job of kind of getting as much content as we could that is even remotely related to retirement accounts and things of that such. So, as far as the emergency savings and other hardship withdrawals, an emergency saving beginning in 2024, an employer can add provisions to a defined contribution retirement plan to help non-highly compensated employees save for emergencies. So the provisions of the emergency savings fund include, but are not limited to, an annual distribution limit of $1,000 annually. Funds are used to cover unforeseeable or immediate needs for personal or family emergency expenses. Only one distribution can be taken per year. Distributions are exempt from any penalty for early distributions as long as the employee is under 59 and a half years old and an employee has up to 3 years to repay the funds to the plan. If a repayment is not made within 3 years, no other emergency distributions can be made for an additional 3 years. So that's something to keep in mind there if you do have to take any sort of withdrawal for hardship. These emergency savings accounts are separately accounted for and not part of the employee's regular retirement savings. And the emergency savings account balance is generally limited to 2,500, but a lower amount can be set by the employer. As far as the hardship withdrawals, employers can add provisions similar to the emergency savings plan for participants who are terminally ill or victims of domestic abuse. As far as disaster related distributions may be taken and are exempt from the 10% early withdrawal penalty if they meet the following criteria. So, A, the individual withdrawal is no more than $22,000. B, the individual's principal place of residence is in a federally declared disaster area. So, obviously, this is very specific. So there is some underwriting, if you will, to this, and the individual has sustained an economic loss as a result of the disaster. So certainly that's a little bit more up to interpretation, but certainly the federally declared disaster area is pretty black and white there. So now, as far as RMDs, required minimum distributions, again, some more good news here. The RMD age is delayed. So prior to January of 2023, an individual was generally required to take an RMD from their retirement beginning at age 72. Beginning on January 1 of 2023, the Secure Act increases the RMD age to 73. And by 2033, the RMD age will be moved up to 75 years old. There's also some great news with the RMDs. Certainly, there are some that really are enthusiastic about taking required minimum distributions. They can start to pull money from their retirement accounts, while others are in a solid financial position, aren't really interested in taking a required minimum distribution, but certainly at some point in time, they'll be pulling monies from the account. So there aren't any RMDs for a Roth 401k. So as of 2024, the Secure Act eliminates the RMDs for qualified employer Roth plan accounts. There's also a reduced penalty for missing that RMD because, again, that's something where the account holder has to proactively request a distribution to be made. So the under distribution penalty for failure to take the required minimum distribution is reduced from 50% to 25% and may be further reduced by 10% in certain situations of a timely correction. So, of course, if you just slightly miss the deadline and you kind of take that distribution out quickly, there could be a even lower penalty than the 25% there. So certainly as far as the Secure Act goes, it's certainly beneficial in our mind in a lot of different ways. The information provided is an overview of the Secure Act 2.0 as of 2022 and is intended to provide general information about certain provisions of this complex law. The Secure Act 2.0 could impact your retirement account and in turn potentially your taxes and tax benefits. While these changes provide increased opportunity to save for retirement, everyone's financial situation is different. So, certainly, it's really critical to understand that we do ask that you still consult with your financial advisors, attorneys, and tax professionals to understand this law and the changes being made. Again, I think our legal team did a phenomenal job of creating some quality content here that you're going to have the ability to sit with and read through and perhaps present to your professionals to get their understanding and help guide you in your personal situation based on this. But this essentially shouldn't be taken as as your total education on the Secure Act 2.0 concept here. It's the starting point. It's a great way for our legal team to kind of bring some value to our client base.